everybody, to a beautiful fall day. Leaves are still on the trees, so it's great. My name is Dan Burke. I'm the Executive Director of the Door County Land Trust, and I just want to thank you for coming out here today to spend a couple of hours getting free legal advice, as I like to say. I'm going to first introduce our board president, Tim Stone, to have a couple opening remarks.
I too thank you for coming today on this magnificent fall day. What a drive down in here with the soft sunlight coming through the trees. So we really appreciate you giving up your fall morning to go spend it with us. And we are delighted to sponsor this program on estate planning. And I also want to assure you that as an organization, we are absolutely committed to our long-term sustainability of the Door County Land Trust. Those of you that know Dan know how outstanding he is, and he's built an amazing staff. We have a dedicated, committed board of directors, and an amazing membership group and volunteers. So with that, I'll turn it back to Dan. Again, thank you for coming.
Great. And before I turn it over to Dick Hauser and Grace Rossman, I just want to put out a couple of thank yous. First of all, to Cinnamon Rossman for helping to organize today's event with me, so thank you very much. And to thank the Bjorklund staff. I don't know how many of you come to meetings here, but they always do such a great job in welcoming us, and I'm sure they do it with other groups. They're just amazing. So thank you to Kim and their staff for welcoming us here today. Just to give you a little bit of a picture for what we're going to do over the next hour or two. We're going to have about a 45-minute presentation in which Grace and Dick will lead the plan giving portion of that presentation. And then we're going to open up for questions. We'll probably have at least 20 minutes, depending on how many questions are fielded during the presentation, but maybe 20 minutes to a half hour of question and answers. So if you have things on your mind, that would be a great time to ask questions that either came up through the presentation, or you may have come here with some questions in mind that you wouldn't mind having our guests field. So there will be a question and answer, and then I'll come back up and just speak a few minutes about the Door County Land Trust, a couple of projects we're working on, and to explain a little bit about what's in your packet and what's on the table that you can leave with here today. So with that, I want to introduce our two guests and to thank them so much for coming here and spending the morning with us. We have Grace Rossman with Thrivent Financial and Dick Hauser with Pinkett Law Firm, both of whom we have the pleasure with the Door County Land Trust of partnering with and working with. Both of their companies are business members of the Door County Land Trust, so we thank them for that. And we've been working with Dick for a number of years. He served on our endowment trustees for probably the first 8 years of our endowment's inception, maybe 10 years. So we have a long working relationship with Dick and Grace, and they both agreed to come and to speak to our members and guests today about plan giving and how that's important for your lives, and how plan giving can benefit organizations like the Land Trust as well. So with that, I think I'll turn it over to Grace and to Dick and have them take it away.
Thank you, Dan. So Dan, how do you switch this? Well, there we go. Hold on a second. Now we got to all log in.
Technical glitch. You know any attorney jokes to open up the day?
No, well, a couple of Land Trust executive director jokes.
Oh, well, looks like we're all set.
Oh, that was scary, huh? Okay. All right. So, let me ask you a true-false question. Everything you own goes through probate. Anybody know? Val says, no dice. Let me paint you a scenario. You're in a car accident and you're in a coma, and you need to get to some money to pay for your bills, and your spouse goes and asks for money out of your account. And because they are married to you, they get to do that, right? Okay, I think our job is done. So that's what I'm going to talk about a little bit today, is just some of the stuff that is really elusive about estate strategies. And everybody thinks that involves writing a will. And that's pretty close. This is a screen of propaganda about me. I'm a certified financial planner, and I do represent Thrivent Financial, and I help a lot of people get ready to create an estate planning strategy. I don't write a will, and I don't write a trust. That's Dick's job. Dick is with Pinkert Law Firm, and with the two of us on your team, I think you could probably solve almost any problem, except maybe world peace. So, what goes into an estate? Anybody know? Does your house belong in your estate? What about your old 401k? What does not go into your estate? Your pets.
Actually,
You know, I'm going to cover that. Basically, anything that you own is part of your estate. And here's an interesting little factoid. I've run into this once or twice. Stuff that you may be entitled to after you're dead is part of your estate. You get smashed by a Mack truck and your family sues the Mack truck driver, you could end up with an estate after you died. Weird but true. Am I right, Dick?
you are.
Look at that. I guessed right. Okay. So when you're putting together an estate planning strategy, it's frequently run by the values that you have. And people don't frequently think about it that way, but it really begins with how you feel about the groups and the people that you love. And so that's going to drive everything that you do about your estate plan. And that, of course, leads then to identifying what do you want to do? What are your goals for an estate plan strategy? And most people say, well, I want to make sure that the people that I care about get my assets. But there's a lot of other things that can happen too. One thing you should be concerned about is to avoid any family feuds. If it's all written down and planned ahead, no one can argue about that. So you need to have some help from some financial and legal professionals, and that's why Dick and I are here today. Here are the 3 must-haves. Wouldn't you agree? So the will simply says who's going to get what, and it can also add on a whole lot of bells and whistles. The durable power of attorney I'm going to cover in a minute, and also the advanced medical directive. So, the will talks about who gets what, but it can also set up some other things for you. For instance, if you have minor children, are any children minor really when you think about it? But, so if you have minor children, and I bet everybody here has minor grandchildren, it looks like, right? You need to talk about what happens if both parents die. Who gets those children? Who is responsible? Who is the guardian? If you don't put that in a will, the court decides for you, and it may not be exactly what the parents thought. And if you're hearing this and you're thinking about your own grandchildren and whether or not they have been dealt with in a will, talk to your kids about it. It's an important issue. And of course, you're going to name who's going to settle your estate. You know, generally speaking, every family has the smarty pants kid that runs everything anyway. Well, yeah, that kid should be your executor, obviously. Maybe you have an estate that doesn't include a family member. Maybe you have no children. You can name an institution then to serve as your executor. So, here we have something. Everybody thinks this is true, right? Everything that you own passes through your will. but there's a lot of stuff that doesn't go through your will. For instance, beneficiary designations trump whatever your will says. So Dave walks into my office and says, well, I've got this life insurance policy, but now it's going to go to my cousin Thelma because I changed my will. No, it's not. It's going to go whoever is named on the beneficiary. Thrivent Financial settles about 20,000 claims a year, death claims. And of those claims, there's about 6,000 that have a little surprise because somebody didn't pay attention to the detail of that. And I've been doing this for 24 years, and during that time, it is astonishing how many times I have delivered a check to an extremely surprised but delighted ex-spouse. I delivered $120,000 to the second wife of a guy. And she told me, man, this guy hated me. He threatened to kill me, et cetera, et cetera. And here's the real ringer. He had 2 wives after her. He never did his paperwork. So there's something to think about. If you've got an old policy out there and you haven't looked at it lately, please do. It could be that you've still got your mom and dad on it. That wouldn't be surprising. And if a beneficiary designation just is complete hogwash and everybody that you named is already deceased, guess what happens? It gets swept up into your estate. So that's what I just said. So a will, once you write it, then certainly you are done, right? Stuff changes. And so you need to review frequently and think about what's in there. Probably the scariest conversation I could have with somebody would be, have you written a will? Yep, we wrote a will. When did you write it? 15 years ago. Have you looked at it since? Well, no, it's in a sealed envelope. You can't open the envelope. Yes, you can. You can open the envelope and you can read exactly what it says. And you should. And here's the thing you should not do with a will, and Dick will probably agree with this one. How about you take out the will, you find out you don't want to give all your money to Cousin Thelma, so you cross it out with ink. Huh? Oh, and then you get your neighbor to witness your new signature. Good idea? No. The second you lay ink on a will, that leaves it open for the court to decide what did you mean, really. Dick is the only guy that can say what you really meant. He's going to write a codicil and change it for you that way. So, these are the reasons that you would review a will, and there's one real typical one that happens in Door County, and that is the third one. You came from a different state, and you have a will that you wrote in Arkansas. Well, the state laws are different, and intestacy laws are state laws. So you should, at the very least, ask an attorney to review it and look at it and make sure it applies to the state of Wisconsin. So, probate. It's required for any assets that are titled in your name when you die, except for the things that pass by beneficiary or by some sort of title. So, for instance, you own a house in joint tenancy. That says when one of you passes away, the survivor owns the house. But what about if you bought the house 40 years ago when you were single, got married, you've both lived in it now for 40 years, you die, and it's only titled in your name? That's probatable. So reviewing how things are titled, who actually owns them. When I get people ready for an estate planning strategy, that's one of the first things we talk about is bring me what you own and prove to me who owns it. Okay? So a will is only going to talk about what is probatable. Everything else is going to be dealt with by how it's titled or its beneficiary designation. So, there are things that you need to think about when you're talking about your estate planning strategies, and these are some of them. 401ks. You know, you can actually hold a 401k without a beneficiary designation. Or you could do yourself a real favor and say that your estate is the beneficiary. These are bad ideas. Because 401ks generally hold what kind of money? Did you pay tax on it? You did not. So wherever it goes, first guy to touch it pays income taxes. Your investments. You could have an investment portfolio. And this can be kind of a sneaky thing. You ran into the stockbroker's office, you plopped down a check, you told him, you know, I want to buy a whole bunch of Exxon, you know, where do I sign? I'm out of here. Boom. You owned that. Your spouse didn't own it. And you didn't put a transfer on death designation on it. Boom, probatable. There's a lot of ways that you can really simplify probate by thinking carefully about these issues. And the last one, long-term care insurance. That's really, it's like fire insurance for your estate, because you can go through all the planning about estates, but if you end up consuming your estate because of a long-term care incident, you sort of destroyed it. So I think it's important to include that in your planning. So what is a durable power of attorney? Who's got one? That's good. You all get A's. A durable power of attorney says that you're going to name somebody to deal with your financial matters. And you can customize it and personalize it. Dick writes them all the time. So he can say, do you want your power of attorney to be able to make gifts out of your money for you? And this would be while you're alive, but you can't speak for yourself. Perhaps you're unable to speak, you're unable to write, perhaps you're, you know, losing it a little bit, and so your power of attorney is taking over your business for you. So these are things that you need to think about, how much you're going to allow your durable power of attorney to work for you. And who is your durable power of attorney? Most likely one, children, probably. You can have a professional person do it, but generally speaking, it's going to be a family member. Do you find that, Dick?
Yes.
So, remember that question I asked in the beginning about whether or not your spouse can do your dealings for you? If you don't have a durable power of attorney and something happens, the court is going to appoint you as a guardian. Is that fun, Dick?
Not much. Guardianships take time. They're actually fairly expensive, and it's not pleasant. I mean, yeah, it's a tough thing to go through.
Yeah.
So.
And if you're seeking guardianship, guess what? It's not your favorite day of the week. Things have happened. This is bad. So you've got a trauma, you've got a crisis, and then you're showing up and you're asking Todd Ehlers or someone to make you guardian. And once you're made guardian, it's not over with the court. You have to report to them and let them know you're doing your job right, because they're overseeing it, because you didn't have this document. Of every document that you could create, in my opinion, this is one of the most important. I would rather you had this than a will, in fact. It's very important.
It's important, and it's easy to do is the other thing about it. It's just picking an agent, naming who it is, and for the most part, a power of attorney is a fairly standard document, so there's really is no reason not to have that in place.
Exactly. So, you're going to name the person, and then you're going to say, you're going to put a little bell and jingle on it. You can say, it's a durable power of attorney, and I want you to be able to use it any time. So, for instance, if you're traveling out of the country, you could actually know that there's somebody at home who could take care of your finances in the event that you're not able to because you're gone. Or you can say it springs from a situation where you've lost the ability to speak for yourself. It ends when you die. Little known fact. So this is not like the executor. Once you've died, you can take that durable power of attorney, that's no good. Tear that up. Doesn't matter anymore. Who knows about advanced medical directives? Have you had any experience with it? Anybody going to talk? So did you have the opportunity to serve as a healthcare power of attorney, or?
Well, I think it's more emphatic when you get really the gist of it if you lose a spouse.
Yes.
And my first spouse was a nurse, and she was very practical on the end of life. And I learned a lot from that. And so when we got together with Dick up here, I transposed what I went through into my medical power of attorney as what I want to have happen. And it's terribly important because it's a crisis in a hospital. It's a crisis when the kids don't know what you want to do. I think it's one of the most important documents you write, period. And I think it has some applications here in Wisconsin that's different than in other states. I'm not sure. Is that true, Dick?
That is correct.
So if you've got one that was written in Iowa, like I did originally, you better get some attention to it when you get up here.
Thank you, Ken. It seems as though if you've had a real life experience with a medical directive of any kind, it really cements the idea that you're going to use one yourself. What the advanced medical directive,
You know, that's a hard way to learn.
it's a terrible way to learn.
Yeah, I mean, don't take my example as a thing to do.
Well, and here's the thing of it. Your doctor is committed to extending your life. That's his job. And he's going to do that unless he has the legal authority to say, okay, we're calling it done. And there's a lot of times when somebody does want to call it done, but if they don't have the document that speaks for them and they can't tell the doctor themselves, no one else can tell them. So, for instance, the Chavo case in Florida, notorious case, it happened quite a while ago now, you may recall it. It was a young woman, I believe she was about 32, if I remember correctly, was in a car accident and ended up brain dead in a coma. And she had a young husband, no children, and she had a set of parents. And her husband and her parents duked it out in court. And I don't know if you remember, but in the end, there were pickets in the yard in front of the nursing home that she was living in. And the court finally gave the husband the authority to speak, and he pulled the plug. And during the autopsy, they discovered that her brain, would never have come back. It never functioned. But what a tragedy. And it took, I think it was 2 years that they duked it out in court over that, all because she didn't have an advanced medical directive. So, when should you have it? Obviously, this woman, I believe this woman, when it happened for her, was younger than you, Cinnamon, who, by the way, is my daughter, in case you were wondering. So accidents happen, and I've seen it in my own practice. I'm sure Dick has as well. You get a frantic call from somebody, My husband is, there's a brain aneurysm, and they're asking me what I want to do, and do I have the authority to speak? And, I thought about you right away, because we wrote a will. Do I have the authority to speak? Well, in that particular case, she did, yes.
I have a question on this, on the strength of the advanced medical directive. Let's say you have a directive that says that I do not want treatment beyond a certain point. That point comes in and you're in ICU, and the institution doesn't believe in terminating treatment or allowing that directive to go through. Who's responsible? I mean, what does the law say on that?
That's an excellent question. What he's talking about is you have an advanced medical directive that gives instructions to whatever healthcare professional is treating you. And your medical directive says that I don't want to extend my life if it's obviously not going to help. and that you want to stay comfortable, but you want to be allowed to die if that's what's necessary, correct? But in some institutions, there might be a little fight about whether or not they should honor the medical directive, correct? Have you run into that, Dick?
I have not personally, or I mean even with clients, had that situation, but I have had the question asked, and it does seem that the hospital has some say in what route they'll take. You might have to find a different doctor at that point. You know, if your doctor, they've got they've got the right to make some determinations in that situation, is my understanding of it, so that you really...
It's the institutional code. Some religious beliefs will not terminate life.
right.
Correct.
Even if it's on artificial support.
And so, even though I didn't script you, you're exactly making the point I'm going to make now. The difference between a medical directive that talks just to your healthcare provider and a healthcare power of attorney. The what we will call the living will here talks to just a general group of people you haven't even met yet, maybe, who you're saying, you know, don't keep me alive, I don't want any sustaining measures taken, I want to be comfortable, but if I'm brain dead, pull the plug. And that's left up to a lot of interpretation. And your loved ones are watching all of that happen, and they don't get to say. But if you have a medical power of attorney, a healthcare power of attorney document, and your loved ones are holding that and saying, I am the healthcare power of attorney, and this is the decision that we have made. There's no arguing. Tom?
Grace, and to expand on this, if you have a living will advanced medical directives made up in the state of Wisconsin, and I would expect most of us in here occasionally travel, maybe even travel into Canada or overseas, do these things apply then, or are we into a whole nother?
What do you say, Dick? The question is, just so that we can catch that, does a healthcare power of attorney apply in a different state or a different country?
And I guess I can only go from, Wisconsin does recognize power of attorneys that have been done in a different state. So I would think that most states would certainly recognize a Wisconsin power of attorney healthcare, that most states. Now, I don't know why a different state wouldn't, but there are things, and that does bring up a different point, and Grace kind of touched on that. In Wisconsin, there are, or maybe it was Ken, there are certain things that need to be specifically stated in a power of attorney for healthcare. And going back to the fact, just by being married to somebody does not give you the right to make their healthcare decisions. So you do need that power of attorney for healthcare. But Wisconsin also specifically provides that if you want your agent to have the authority to admit you to a nursing home, if you're not able, or for long-term nursing home care, that has to be specifically authorized. A lot of states don't specifically authorize that. So if you had one done, and I think Illinois, for example, doesn't have that specific provision in it, it's important to get a Wisconsin healthcare power of attorney with that specific authority. So, I mean, whether Canada would or not, I don't know, but it kind of depends how general their law is.
So it's safer if you're going to have this kind of a health problem to do it in Wisconsin.
It's always good to do it at home, Tom. So, here's another consideration. What about using a trust? Have you ever heard of a revocable trust? So, with a trust, you can do some extra little bells and whistles that you can't do with a will. So, let me name you a name and see if you remember this woman. Leona Helmsley. Yeah. She had a couple dogs that she cared very much about, and she wanted to create a situation where they would be taken care of for the rest of their natural lives. And she did it with a revocable trust. Perfect. But you can do all sorts of things. You can say, all right, I'm going to leave my estate to my kids, but they're not going to actually get receipt of the funds until they're all 60. That's what we did. Oh, just kidding, Cinnamon.
It's actually 70, right?
Yeah, it's 70. And so you can say all sorts of things inside of your trust. You can put in little bells and whistles that will create a situation where you sort of, I hate to say it, try to control things after you're gone. I had a client who said, well, in my trust, I want to, there's a son who refuses to paint his house, and I don't want him to get any money until he does it. I said, man, that's an argument you should have while you're alive, not when you're dead. Dan?
How does a trust and a will work together? Is a trust a super will, or are they two documents that work together, or how do they come together?
That's an excellent question. You're going to write both of them, right, Dick?
Right. With a trust, normally it's going to, in a sense, take the place of the will because it's going to give the directions how to distribute your assets after your death. But you normally have a will that goes along with it, just in case, and I guess because a trust only determines the distribution of assets that are actually funded and in the trust, titled in the name of the trust. So you still need a will as a backup. If you forgot to get something in, if when you die you've got something in your individual name, the trust is there, and normally what's used is what's called a pour-over will that says, on my death, if I've got anything in my individual name, it should be added to the trust so it gets distributed according to the provisions of the trust. So.
And that last line, sometimes a trust will protect assets from creditors. And let me underline, sometimes, depends on the kind of trust you're using. So, there's all kinds of things that happen when a person passes away that creates a situation where it kind of whittles away at your estate. You have all these final expenses. Used to be that Dick and I talked a lot about estate taxes. We don't do that very much anymore. If a couple is anticipating an estate of over $10 million, then we've got issues, but otherwise probably not. But there's a lot of things that can devalue an estate, and with the right kind of strategies, you can actually plan ahead for them. What you don't want to see is where each of your heirs receives some cash, and then they all have to cough up again to pay out for different expenses that were not anticipated. So it's kind of an important planning strategy to think about, ready cash when you need it. And using some tools that I happen to offer, and thinking carefully about how they fit into the strategy can make a huge difference. So, once you've written the will and you've got your healthcare power of attorney and you've got your durable power of attorney, then you're going to put them in a safety deposit box and hide the key. Because these are valuable documents, right? And this happens. Families don't know where to find the documents, and they're powerless without them. So you have to understand that you have to tell people where stuff is. If you've got a healthcare power of attorney agent who's already named, you've got the document, give them the document. Why not? Because you don't get to choose when you get sick. At the very least, let people know where your stuff is.
How copies of documents, do they have any, like if you gave copies to people, does that hold any weight, or does it have to be the original, or how does that work?
Under Wisconsin law, a copy of a power of attorney for health care is considered valid and enforceable and can be used. A power of attorney, it somewhat depends on the institution that you're taking it to. They, kind of like doctors or hospitals, can have their own rules, what they'll recognize as far as directions. A bank can say we need to see an original. Normally when we do a power of attorney for healthcare, a power of attorney for finances, we'll put in it that a copy is valid and should be used, recognized also. But you still got to kind of deal with if Thrivent says we need an original, you could probably go to court and force them to accept a copy, but you don't want to go through that process. So you've kind of got to deal with what they're going to say they need. So it a little bit depends.
We'll take a copy. But yeah, there are some institutions who are kind of sticklers about that, and I don't know why. They believe in the U.S. Post Office, because if you're requiring ink, the only way you can move it around is by mailing it. So that's a problem too.
Grace, can't you have more than one original copy?
Yes, you can.
Yes.
Excellent point. And I think, don't you usually do a couple of them, Dick?
We
don't
usually
you?
do 3.
Okay, yeah. Now, with the healthcare power of attorney, one thing you can do, if you've got it and you're satisfied with it, you can bring it to your doctor's office and have them scan it in and keep it electronically. Because now, with electronic medical records, that can be attached to your record. What a godsend. My sister's husband ended up with a health crisis a couple of years ago. He went in for just a mundane little procedure, and long story short, he never left that hospital. But there was a point where they were asking my sister to make decisions and whether or not she had a healthcare power of attorney, and she said to the social worker, "Yes, I do, and it's in your electronic files." And it was! And it's a good thing, because she had no idea where it was. You know, and when you're in a crisis situation, it's no time to find out. Location of passwords. I lost a classmate. Yes, Marilyn?
I just have a question about the scanning and carrying it, because many of us travel, you know, beyond Wisconsin or beyond our usual healthcare providers.
Mm-hmm.
What if you scanned it onto a memory stick, a thumb drive, and just carried your thumb drive around? Is
You could try that.
Would that work?
It's always-
Yeah, I'm thinking to myself, no, I think I'd rather just die than do that. I love technology. Well, and you know, if you know where to find it, like if you know your doctor has it,
Yes.
you know, and people who are with you understand who your doctor is, I mean, that can be accessed almost immediately.
Grace, could I answer that for technical reasons?
Yes.
A memory stick is just one form of storage, just like a hard drive, a floppy disk, email, somebody else's hard drive. So the nice thing about memory sticks, they're very portable. You also might lose them.
Right.
I have a suggestion that works, but not necessarily permanent. Email it to yourself. Scan it, email it to yourself. As long as you can get to your email, there, worldwide, you can get to it. Or somebody else that has your password. Just an idea.
Thank you.
Now, I paid Laddie to say that because I want to talk about passwords. This is something that is really changing day by day. Who gets to access your Facebook account after you die, as an example? Or you stuck all your family photos out in a cloud, you've got the password, you wrote it down on a little slip of paper, it doesn't make any sense, nobody else knows what it is, you die, those photos are gone forever. You're not going to get them. Maybe you could hire Dick to go after the cloud people and see if they'll let them loose. But there's no rules about this right now. It's very uncertain. So you need to share your passwords. I lost a classmate this summer, and her Facebook page is still up. It bothers me. I talked to her husband, and he's trying to get it down. He can't do it without her password, and he just doesn't have any idea what it would be. So share your passwords, even though everyone tells you not to. Yes?
I wonder if you name your spouse the power of medical attorney, and you're both in a car accident and you both go into a coma. What happens then?
Good question. You've named your spouse as your healthcare power of attorney and you're both disabled in an accident. What happens? You usually name 2 people. You have a first and then you have a second. You can even get fancy and name a third. You can name a team if you want to. Right, Dick?
There we go.
I wasn't thinking of the Packers, but
It's for finances, you can have co-agents, and for power of attorney for healthcare, it's questionable whether you can have co-agents, and for a couple reasons. And one is the way the law is it says an individual may name an individual. But the other problem if you have co-agents for a healthcare power of attorney is if you've named 2 people and they disagree on what to do, the doctor has no way of breaking that tie. So it's kind of not necessarily a good idea. But agents, as you said, in succession, a primary, an alternate, a second alternate, that's as many as you want you can go with.
And then this last line, the letter of intent. If you have a lot of heirloom things or things that mean a lot emotionally, and you want to be sure that they go to a specific person, sometimes just a simple letter or a list that you keep that does that and names exactly who gets what out of your personal effects can be so powerful. And I've seen that happen where families find the list and they divvy up, here's grandma's favorite gravy bowl, here's grandpa's railroad train, watch, whatever it is. That is just a private list. It can be referred to, correct, in the will, and you can change it.
It can, and if it's referred to in the will, if the will has a provision that says I may leave a list or lists, then that list is enforceable and legally has to be recognized, provided that the person that finds it doesn't tear it up before anybody else sees it. But it is an enforceable. If it's not, if you don't have that paragraph in the will, I think it's just then a letter of intent that you hope that the kids follow. But if you've got that provision that says whatever lists.
Yes.
Just one thing on passwords. I think it's a bad idea to leave the impression that when you share passwords, you should do it in an appropriate way. Don't email your passwords to people.
Yep.
Unless you want to share it with a lot more, then, because that's not secure.
Yeah.
If they're important to you.
And that's a very good point. Passwords need to be shared very carefully. Perhaps if you just said, FYI, I've got all my passwords, I always write them down and I put them here. Then a person knows exactly where to look for the most current password. Here's some propaganda about Thrivent Financial. We are a nonprofit group, which means that we answer to our members who do business with us instead of Wall Street. And yet we're a Fortune 500 company. I said before, I'm a certified financial planner. I'm also a certified advisor for philanthropy. Yes?
Do I understand that it's no longer required to be a Lutheran to take your services?
That's correct. We serve people of all faiths, or even no faith. Oh! Sorry. Back in the day, it was a Lutheran organization. You had to be part of a Lutheran group in order to be eligible for membership, but that has changed. Thank you. Now, I've got a checklist that might just help you remember a couple of things. And Dan, do you want to pass one out to each couple? And you can also go out on Thrivent.com. There's a will planning guide out there if you are so inclined. And certainly Dick and I are available to meet with you. You will see inside of your folder here that Dick is making a very generous offer. He's reducing his fee by 15% for anyone who wants to do some estate planning with him. And in my office, I always get you ready to go see an attorney, and there's absolutely no charge for that. So I hope that you'll take advantage of the team that stands before you. Also in that folder, Dan put in a little thing like this, and this is the thing that we're going to talk about next. So let me just gear up for that. Does anyone have any questions about what we've covered so far? Were that thorough? Were that good? Yes.
Can the decision that's stated in the will, let's say you have property, or you have something of value that's of interest to certain people. The will designates that property or that thing of value go to institution A. Can that be challenged?
The question is, I've written a will, and I've included in the will a bequest for a charitable organization. Can that will designation be challenged?
Everything can be challenged. It's just whether or not it's likely to be successful. And really, once you've done a will, there's three main bases for challenging a will. And one is competency. As long as you're competent at the time you did the will, you can challenge a will based on undue influence. Undue influence somewhat also gets to your mental state of mind, whether there was a reason that for undue influence to be a valid challenge, the beneficiary has to have been in a position to unduly influence you. And the third is really that the will isn't valid because it wasn't properly executed, signed and witnessed. And we certainly make sure that if we do a will for you, that we want you to come in and we have you sign it in front of us and make sure the witnesses are there so that that's eliminated as a challenge. So it can be challenged, but probably not successfully as long as you were competent at the time. Yes, Tony.
Dick, are there any issues if, let's say you had a document and then you reviewed your documents and changed something and you didn't get rid of the old one somehow? Does the date take precedence, or can you get into a challenge on that basis if you keep the old documents around?
In most cases, a newer document will revoke an old document, so having the old one doesn't normally cause problems. The situation that can cause problems is if you later, decided I don't like the new one, and you can revoke that by tearing it up. In some cases, that can reinstate the old one if you didn't get rid of it also. So, that's the kind of situation where it can haunt you. Sometimes it's good to have the old one, sometimes it's bad, and it's kind of depends on what you did. Sometimes it's good that the old one, you haven't changed it a lot, so it shows a consistency, and it shows maybe the reason for what you've done. Sometimes it's just bad in that you've had somebody in it, and now they're not, and it can give them an argument or something. But so it kind of depends on the situation, I guess.
I have observed a couple of cases where people got excitable about one of the beneficiaries of their estate and decided to amend it to take that person out. And that, I think, if you've got an original document, it might be a good idea to rewrite the whole thing, unless you really want to jab somebody after you're gone. It can be painful for people, I think. So, let's talk a little bit about charitable giving. You probably all realize that charitable giving is a thing that you get an income tax deduction for when you give a gift of current value. And because of these deductions, you get to say where it goes as long as it's a charitable organization. Like the land trust is a 501c3, so they qualify. There's a lot of tools for charitable giving, and they are inside of this booklet, which I'm going to give Dan to give to each couple. And it's going to be on page 6. Gives all of the different strategies that you can use in order to create a charitable gift. So, I think probably the main reason that people give is because they care so much about the organization, or they feel as though they've been blessed and they want to give back. But there can be some other interesting reasons too. One thing that I sometimes see in my office is that there's a legacy of giving in the family, and that as the generations move along, they just continue that amazing legacy. And that's really something to be a part of and something to really take pride in. So, you can also do some charitable giving because it's all about you. And that's a happy thing, isn't it? So, we're going to look at some of those strategies today. The first obvious gift that you can do is you can give a gift of cash or a check. And as long as you get a receipt back that says, yes, you gave us this thing, and it's a 501c3 organization, it's going to be deductible for you. You can also use life insurance to amp it up a little bit. You can say, well, I've got enough to pay for premium, but I certainly don't have enough to make $100,000 in cold hard cash. So you use money to buy a life insurance policy. You can assign the life insurance policy to an organization, so you could let the land trust own it. You pay the annual premium. That turns out to be an annual gift to the land trust. And upon your death, the land trust gets the death proceeds. Here's Les. Les is a member of a choir in Minnesota, and he cares very much about the organization. And so he's been making annual gifts all along. So what he wants to do is create a situation where he leaves a large legacy behind, but he's not exactly a rich man. So he does exactly the strategy that I just talked about. Of course, you have to be insurable to use this strategy, but it can be a way to really maximize the gift that you create. What about a charitable gift annuity? Does anybody know about those? You see those pop up every now and again. You might get a magazine in the mail from a group that offers these. But basically what a charitable gift annuity is, it's an income stream that you arrange. You can use cash, you can use stocks, mutual funds, and you create a stream of income for yourself during your lifetime. And upon your death, what's ever left over goes to a charitable organization. And when you create it, it's actually tax deductible to the extent that there is a gift later. So in other words, the shorter your life expectancy, if you're 90 when you create a gift annuity, you're going to get a larger charitable deduction than you would if Cinnamon created one today for herself. So,
Grace,
yes.
does that gift annuity stay in that couple's or that person's name during their lifetime, or is it actually in the charity's name at that point, even, and then they receive the income? Does that matter?
Well, the fine details of it, the annuitants are actually the people who are receiving the income. The charitable organization controls the contract.
Right, okay, that's
So here's an example of that. An 80-year-old woman who wants to create just a little more income. She's got a little cash. She wants to benefit her charity, and so she uses, sure she does, a charitable gift annuity. She gives away $10,000, and she has a charitable gift annuity that in this case turns out to pay her 7.4%. And this is one of the interesting things about a gift annuity is that when you create this with your charitable organization, they will probably pay you out more than the current rate of interest. So it's a way for you to actually maximize some of your earnings and leave a gift. So everybody's a hero here. That's a good way to do it. And then, of course, the remainder goes to, in this case, her church. So who knows about a charitable remainder trust? Anybody hear of that before? Or a donor-advised fund? I'll talk about those two next. Meet Harvey and Doreen. These folks are in their 60s. They're still working. They have a family that they care about, but they also have another real big problem. They have appreciated real estate, farmland. If they sell it, what are they going to have? Capital gains, exactly. So they want to make sure that they have enough money to live on, certainly, but they also want to benefit their daughters, and they've got some charitable organizations that they care about. So they use their farmland to create a charitable remainder trust. So what they do is they give their farmland to the charity in exchange for a stream of income for them now. And they receive a tax deduction because they did that. It's not going to be for the full value of the property because they're going to be getting some income off of it. and then they receive quarterly payments. And they use those quarterly payments. In this case, they're still working, so they're going to make some Roth IRA contributions. They're going to buy some long-term care insurance, and they're going to buy some life insurance for their kids. Upon their death, they know that whatever remains in that charitable remainder trust is going to the charitable organization. A number of years ago, I helped a woman put together a charitable remainder trust. She had highly appreciated stock that her grandfather had given her when she was a child, and she had never touched it. It was plutonium. Man, the thing was loaded up. Just even shifting off a couple of shares, it was incredibly appreciated. But what she did is she titled it into the church's name, and the church created a remainder trust for her. She got some income, and she even put a bell and whistle on it. She said, "Upon my death, I still want you to pay my son for 10 years. And so they did that, and then at the end, when the 10 years was up, the church got the money, and they paid off their mortgage. It's about $500,000. Huge gift. So now there's a wing of the church that has her name on it. Makes sense. What about an IRA? What do we know about IRAs? I mentioned this earlier. If you spend it, what happens? Yeah, income taxes. It's all good. So here we have a couple in their 70s with a grown son, and the wife is all about leaving a little money for a charity, and the husband wants to leave some money for the son. So in this case, they have $400,000 in an IRA, and they have $400,000 in their investments. So they name the son beneficiary of the IRA. Who wouldn't? You love your kid, right? So he gets the money, and here's an amazing statistic for you. 90% of beneficiaries of IRAs cash them in completely when they receive them. Yowza! So this kid is no different. He's got stuff he needs to pay. So he goes ahead and he takes the $400,000, he pays the $120,000 in taxes. Oops, it's ordinary income tax, so it throws you into an upper bracket on top of it. So he gets $280,000 net. So they name the charitable organization for their investment portfolio, $400,000, not bad. You don't have to worry about paying any taxes because the charitable organization doesn't pay taxes. So the total they gave out of their estate, $680,000. Not a bad thing, right? Well, what about if they had looked at something a little bit differently? Because people pay income taxes, but charities don't. So here, we take the $400,000 IRA and we name the charitable organization as the beneficiary. So in this case, you could say, Door County Land Trust is my first beneficiary of taxable money like this. And then name the son for the investments. Because what happens when you die, when you hold an investment? Does anybody know? There's an interesting thing that happens when you die. You get a step up in basis. Amen, Tony. And a couple of years back, Congress even talked about wiping that step up out. But they haven't done that. So when the son receives these investments, they're going to be stepped up. He is going to have a cost basis the same as the current value, date of death value. That means if he sells it right away, no tax for him. So what happened? We just created a situation where every dollar of the estate got used, and the only people who didn't get it, the IRS. I know, it's sad. So there are many ways that you can share your time and your talent and your treasure, but I think the important thing that you need to understand is that you don't have to be Leona Helmsley to do something significant and to make a difference and to start an amazing legacy for you and your family. So I hope that you will refer to Dick and I as you think about all of the things that you've learned this morning. Let me open it up for questions. Are there any questions that people have? Yes, Tim?
With an IRA, is this the last year that you could say we could direct our IRA to give a gift directly to the land trust without flowing through me and paying taxes? Is this the last year?
Thank you. Tim is referring to the qualified charitable distribution out of an IRA. Here are the rules. If you're over 70 and a half and you have an IRA, and I'm talking about a traditional IRA, I'm not talking about a 401k or a SEP or a SARSEP or a KEO, only an IRA. You can direct up to $100,000 of it directly to any charitable 501c3. When you do that, you do not get a tax deduction, okay? And you don't pay income tax on the amount that you withdrew. So imagine if you're in a situation where you don't have a whole lot of taxable income and you know that a cash gift is deductible up to 50% of your adjusted gross income, right? So if you're going to give a significant gift, it may be that you don't even get to take all of the charitable deduction that you could. So in some cases, a strategy like Tim is talking about makes a lot of sense. And Tim, you are exactly correct. As of today, this opportunity ends on December 31st. So be there or be square. And I say as of today because you may recall that it happened for a while and then Congress said, oh, let's do it another year, you know. So we could see an extension, although if I may get political here, it would take some cooperation for that to happen. Tom?
Your example of the couple that had some farmland, and I'm not sure whether it was a charitable reminder trust or something else, but they, as I understand it, gave the land to a charitable organization.
Correct.
Let's say the Door County Land Trust. And then they died after receiving interest on that, or income. They died, and then, as far as I know, then it becomes the property of the land trust. That's right so far?
Yep, you've got it basically correct.
Well, then maybe this question is to the land trust, to Dan. If somebody around here offered you farmland, first of all, you know, what would you do with it? Maybe you would accept it, maybe you wouldn't, because, you know, farmland is farmland. It's a little different than most of the stuff that you save for us. But of course, if we died and you had farmland, you could sell it. I guess that would be profitable.
And let me just cut in there, Tom.
Yes.
What Tom is asking about is some of the details about how a charitable remainder trust actually works. And what he's talking about is the idea of if I give some farmland to the Door County Land Trust, and I think your question is, how does that turn into money? Because we want the cash. And here's the way it works. You title it.
One of my questions, Grace, is really kind of, would the land trust be interested in that kind of land? Or are you selective that you only are interested in the kind that you might be preserving something like the sites that you presently have around Door County? Does it make sense? Do you have rules about that?
Well, rules, we have policies. We have actually a 12-page policy. It's called our land acceptance policy, in which anytime there's an opportunity for us to either purchase or accept a donation of an interest of land, there are certain guidelines that we follow, so we don't always say yes.
Okay.
But if it comes to us unrestricted, we have the opportunity to view it differently than is this something that we want to own and manage for nature preserve, make available to the public, or if it's unrestricted and the donor didn't have any strings attached, would we view this land as a parcel of land that we would sell and then use the proceeds to acquire lands that we would like to have. So it depends on how it comes to us, but we certainly have criteria.
In this instance, they give you the farmland, it'd be yours, then you'd have to pay interest on it, and then you probably have to have somebody come out and look at it every now and then. And so that would be more involved for you, and it's more of a longer term thing.
Right.
And that would be a little questionable then?
Yeah, how we probably handle things today, and Dave and Tim and Kathy and Sharon, correct me if I'm wrong, but if it's not a parcel of land that sort of fits under the guise of a nature preserve, we probably would make the decision that we wouldn't want to own and manage a piece of property that was a working piece of farmland or had buildings and structures on it, that we probably would work to see if we could accept it and then probably sell it. But we may sell it with restrictions on it, such as placing a conservation easement on it, which protects the natural and scenic attributes of the property, but it would go to a...
I just thought the example with farmland was maybe a stretch.
Well, and let me tell you, Tom, about how this would actually work in this case. If you had some appreciated farmland and you wanted to create a charitable remainder trust, what you would probably want to do is use somebody like the Door County Community Foundation to create that trust for you. And then there would be a donor-advised fund inside of it that would direct the proceeds to the land trust upon your death. So the one thing, though, that has to happen, the property has to sell. It has to sell. In order to create a charitable remainder trust, there has to be some money inside of that pot. So it has to sell in order to create the strategy.
Could you speak a bit on donor-advised funds?
Sure. Donor-advised funds are fantastic gifts. There's a bunch of different ways that you can use them. One thing is, if you've got a year in which, for whatever reason, you hit the jackpot and you really got a lot of earned income and you need some good tax deductions, but you're not exactly sure how you want it to be charitably given, or you want to spread it out, you can create a donor-advised fund, and then you advise about exactly where those annual gifts will go. You don't have to make an annual gift in any given year if you don't want to, but you can if you want to. And you can create a situation where your kids can advise as well. So you might be the first generation, and then your kids might be the second generation. Fantastic way to create a legacy of giving. Another thing that I've run into is that people who are still working and are actively supporting charitable groups feel as though when they retire, they may not be able to afford the same kind of gifting. So if they can fund a donor-advised fund and let that sit there so that they can continue to direct payments out of it in retirement, it takes the pressure off a little bit.
On those types of vehicles, does let's say you do it with a mutual fund or however you do it,
Sure.
are they obligated to take your advice? Because it's their money now.
Oh, they absolutely, yes.
Okay.
Yeah. No foolishness there. They're going to absolutely honor your direction. Bonnie, you had a question.
Is there a benefit to, you hear people that put their homes in their children's names. While they're alive, is there a benefit to that? What's the reasoning?
That's an excellent thing. Those were some questions I was hoping somebody would ask because I think it's a very important piece of planning strategy. And Dick is the guy who's going to be able to address that.
There's a couple different. I mean, the basic reason for doing it is just to avoid probate. If you transfer it to the children ahead of time, it doesn't have to go through the probate process. And there's different ways to do it. The most common in the past has been to transfer it, and then normally the parents retain a life estate, which is the right to continue using it for the rest of their lifetime. Recently, Wisconsin adopted a transfer on death beneficiary designation form. In the difference between those two things are, with the life estate, when you've given it, you've given them an interest in the property and you can't take it back. You get ticked at your child, too bad, they've got that interest and You can't do anything about it. Whereas with the transfer on death beneficiary designation, you can revoke that. So if you decide you want to sell that property, you can undo that beneficiary designation and take that. I mean, you've got the freedom to do with that property what you want. One of the main reasons that people will do the life estate situation is to protect the home in the event they need long-term nursing home care. That now all you've got is the right to use that property during your lifetime. And this is not going to go way into Medicaid, but for Medicaid eligibility purposes, it's considered an unavailable asset and not considered in determining your eligibility under current laws. And then when you die, there's nothing left, so there's nothing that the state can recover Medicaid payments that they've made on your behalf against. So that's in the short, really quickly, why a lot of people will transfer it and retain that life estate.
Yes.
Just a basic question. Let's say you set up a charitable IRA and designate that it's gonna be for, say, $100,000. And a few years pass and the amount in the IRA exceeds your $100,000 target, and it's now getting to be 150 or more. Is it better to split off the excess into a separate charitable IRA with a different beneficiary, or let it stay in the same IRA? Are there any legal differences between those two?
There's no legal differences. And what the question was is if I have an IRA and I name a beneficiary that's a charity, and then the thing grows, which can happen, we've seen it, not so recently, but then the amount gets larger than I wanted to leave for the charity, should I split off some of that and put it into a separate contract and then name a different beneficiary? And you don't have to go through all that work. You can just redo the beneficiary designation and say 67% goes to Door County Land Trust and the other 33% goes to Grace Rossman. I'll give you my address. Yes, Mark.
As a will, I just have a statement. I visited my mother one day and she says, I'm making a will, this is what you're getting, this is what your sister's getting, what do you think about that? I think that's kind of unusual. Most of the time, I don't hear people discussing what the will is going to be before they die. It's kind of like, you know, the old TV series, who gets what?
Yeah, you know, everybody has seen the movie where you're in a dark mahogany paneled room and the lawyer pops open the envelope and they all go, oh, big excitement. And actually what Mark is talking about is the idea of talking in advance about what you decided to do. I vote for that 150%. And being a math teacher, you know how likely that's going to turn out. But you know, if you think you're going to surprise somebody, don't. This isn't anything to surprise anybody with. They need to know. They deserve to know. And in some cases, you might be surprised at what you get back. For instance, right now I'm just working with a family where we've got mom and dad, farmers all their lives, one son, 2 daughters. And they're traditionalists, and so are the daughters. So the daughters have already said they don't want anything to do with the farm. And so they're duking it out right now. They're struggling with, well, if we give the farm to the son, those daughters aren't going to get anything. You know, we don't know what to do. And the very first thing I said to them is, have a family meeting. You know, bring them all in here if you want to, and I will moderate. But find out what they feel about it all. And so they all came, and we talked it over. And guess what? The daughters are fine with that. Mom and dad don't have to worry. So think about the peace of mind that was created by simply just talking about it in advance for everyone. It's a good strategy. Okay, Cinnamon, it really is 60. Any other questions? Dick, could you talk just a little bit about how a marital property agreement would fall into all of this? Because I know that's a strategy a lot of guys use.
Sure. And it's important. Grace talked at the beginning about when it's good to review your will if you're moving from a different state. Marital property is important. A marital property agreement under that circumstance is also important. Wisconsin is a marital property state, which is different than all but 7 other states, which are community property states, in the sense that what you acquire while you're married in Wisconsin is marital property, meaning, for the most part, meaning that no matter how it's titled, it's considered to be owned 1/2 by each spouse. And there's benefits to that from the tax standpoint. Tony mentioned before the basis adjustment on the death of an individual. In most states, when a person dies or a spouse dies, the first spouse, their half interest in property gets that basis adjustment, but the surviving spouse's half interest doesn't. With marital property, both halves get that basis adjustment. Again, if you moved from Illinois into Wisconsin, marital property law doesn't apply for everything that you brought with you when you moved. So one of the benefits of doing a marital property agreement is you can reclassify your property so that marital property law applies, and on the death of the first spouse, the survivor will get that full basis adjustment and can eliminate a lot of capital gains taxes. That's one main reason for a marital property agreement in the estate planning standpoint. The other is you can use a marital property agreement to avoid probate. Wisconsin's marital property law provides for spouses to give directions how their assets are going to be distributed on their death without having to go through probate. And it's very effective in trusts if you've got a revocable trust. I mentioned before the pour-over will, that a pour-over will is a backup to the trust if you forgot to put something in. Well, the marital property agreement is in an even better way, because if you've got in that marital property agreement that on your death, if you own anything outside of the trust, it should be added to that trust. Instead of having to go through a full probate proceeding to make that happen, we can usually do a petition to the court that they'll approve within a day or two, and then we can take it to the financial institution or have recorded if it was real estate that gets that property transferred in the trust. So now the trustee can deal with it without having to go through that full 6, 9 month or 1 year long estate proceeding that would have otherwise been required. So those are just a couple of benefits of the marital property agreement. But as I said, for people that have come from outside of Wisconsin, it's important to get that property reclassified as marital property and get the full benefits of it.
Thank you.
Sure.
Anything else? Yes, Carol.
Someone has their primary residence in Wisconsin, but owns another property in another state. Is there any way of avoiding capital gains, huge capital gains tax in that?
Carol's question is about being a primary resident in Wisconsin, but then having an out-of-state property, and concerning about capital gains upon death, you're thinking? Dick, you want to handle that one?
Even if they were to sell before death.
Oh, to sell it now.
Someday.
Yeah. Well, one way that you can escape capital gains, of course, is to give it away and then create an income agreement off of it, just like we talked about with the Charitable Remainder Trust. That would certainly be a strategy that would work. What about that, Dick, as far as estate planning goes when you have out-of-state property?
On death, it gets the basis adjustment, so it would, if it's sold after your death, avoids the capital gains tax. During your lifetime, other than charitable gift of some sort, if you're willing to make it your primary residence for 2 years, you can then get the $250,000 exemption from capital gains on the sale of a primary residence, but you'd have to establish it as your primary residence for 2 years. $250,000 for an individual or $500,000 for a married couple is the exemption for a primary residence.
But you say that if it isn't sold until after one dies, then there would not be capital gains on it?
Correct. I mean, if it's sold shortly after death, there is the basis adjustment to date of death value for your estate or your beneficiaries when they sell it. They only have to pay capital gains tax on the difference between what they sell it for and what its value was at the time of your death.
Oh, all right. Thank you.
Sure.
Well, thank you very much for your kind attention. I hope we've helped. If you would like to contact either Dick or me, you've got our contact information, so. Is it chocolate?
Well, you'll have to find out.
Ho, ho, ho. Happy me.
Well, we've been talking a lot about today about, sort of looking ahead, planning ahead, making sure your years of hard work do good into the future. And at the Land Trust, looking ahead is something we do all the time. Because we're dealing with perpetuity. We're accepting lands that are entrusted in us to steward and care for into the future, for however long that is. So we always are thinking about the future and how to maintain strength beyond where we're at right now. And as a board of directors and as a staff, we're working on a few angles of that. Some things you may not know. Did you know that the Door County Land Trust has 32 nature preserves throughout the county that we own and manage, that we're responsible for the perpetual care of? 13 of those are really high visible preserves with over 20 miles of hiking trails that we've established and we now maintain. And with the advent of Hines Creek, and we have some purchase agreements that will establish a couple of more very unique nature preserves throughout the county. You can imagine that as we get older, the amount of responsibility we're taking on. So the idea of perpetuity is always in our mind, and strength. So we're doing a few things in terms of shaping, providing that strong foundation that we need to rest on. One is we have a very strong membership program. If you provide an annual gift to the Land Trust, that goes to our Special Places Fund, which funds all of our program work. One of those dollars may go to purchase a piece of land. One of those dollars may go to help maintain and establish a nature trail, or run an educational program, or pay my salary. So, we also have a legal defense fund. That fund is, you can imagine being a landowner of so many lands, and we actually have over 65 private properties that have conservation agreements on. The Sills have a conservation agreement with us, for instance, on their property. It maintains in private ownership, but we have the perpetual and permanent responsibility to oversee the terms of those agreements. So we have a legal defense fund set aside that in case we ever have challenges on our lands, whether it's a trespass issue on lands we own, or a future owner of a conservation easement says, no, I am going to subdivide this and build houses on here, we have to react, and we have to have that surprise be dealt with. And so we have money set aside for that. But most importantly, we have what is called an endowment fund that we've established. The endowment fund's goal is to kick enough interest off from the investments that we have that would be able to provide the annual costs it takes us to care for our lands. We did some estimation, and you may be surprised to learn, but our stewardship program, the amount of money we put into caring for our preserves, monitoring the properties that we own, and restoring lands that may be degraded and we want to bring back to a healthy state. Right now it's about $175,000 a year that it costs us every year just to maintain what we have. And of course that number keeps on growing. And that's just to run a very basic stewardship program. Our goal is to have an endowment fund kick enough interest off that if everything bad happened to the Land Trust, that we would at least be able to have enough resources on hand to care for everything we've accepted to date. We're not quite there yet. Our endowment fund, which our chair, Tony Fiorato, sits on, just surpassed $1 million on September 30th, which we're very proud of. But just to cover our current costs right now, we're estimating that our endowment needs to be over $4 million. So we've got a ways to go, but we have some pieces that are in place to be able to do that. Why I mention the endowment is it links right into planned giving. Our board of directors has a goal of sort of attaching planned giving as a way and as a means to really grow our endowment. So we have a policy right now that if a gift comes to us through a planned gift, through a will or a bequest of some sort, that we will look seriously at trying to put in half that money into our endowment fund, and if we can do more, we will. So if you come to us or into your will and you give us an unrestricted gift, we will look first and foremost to see if that is a place that we can put our endowment, build our endowment. We will then look to see if there's other needs. If we're trying to buy this marquee property and would help to have 20,000 of it, we could consider doing that as well. You could also consider restricting your gift that you give us. If you don't like the idea of the endowment, you want it to go to something right now that we're working on it, you can say, please put it in the Special Places Fund and use it for program and operations. So you certainly have the right to choose, naming to support our endowment or program and operations. But I wanted you to know if it comes unrestricted to us, that we're making a really important point to grow our endowment, because that is our insurance policy, that we're going to be around to take care of all these lands that you are helping us acquire. So we have some good strategies in place, and I feel really proud about the work that the board's done to help put those strategies together. Just want to make one last comment on their packet. This is a little brochure we have on planned giving, and in there is an intention card. If you already have us named in your bequest or your planned giving, we would love to know about it. If you haven't told us already, or if you do plan to in the future, just let us know. We have what we call our sustainer circle, which are those members that have told us that we're part of their planned giving plans. And our goal by the end of 2014 is to have 50 sustainers members. And we're getting close to that amount, so we're really happy about the people that are thinking about us through their planned gifts. So take a look at that brochure, and if that interests you, that would be great. There's also a little fact finder that a former board member and estate planner, Ali Scrivani, put together, and it's just a way to, if you don't have, it's just a way to organize all the things you have, so you might find that useful. And then finally, we put just a little bit of a nice piece together. Last year, the Miller Art Museum ran a curated program. They had 50 painters, 50 of the best painters in our community go out, and for a year they got to select a Door County Nature Reserve in which to do a painting that inspired them, of a place that inspired them. And that collection was all brought together last November and December, if you didn't get a chance to see it. But we helped fund the printing of this packet, which is all those paintings and the artists that were part of this show. And it's wonderful, because it's all Door County Land Trust owned and managed property or conservation easement property. And it gives a little story of why the artist selected that piece. So I think you might enjoy that, and we included a piece for you. We also have, if you don't have it already, a guide to our protected places. And feel free to leave with a copy if you would like an extra one for to leave at your house here, or to bring with you wherever you travel, or give to somebody. And we also have a map of all of our nature preserves. So feel free to leave with those on your way out. With that, is there any questions about the land trust that you may have? Any simple questions, complex questions? Yes, Tom.
I don't have a question, I have a comment. My wife Lucy and I very much appreciate the maps of the places that you have, and the trails and the openness of this group, your group, that keep it not only preserved, but also allow people to appreciate it.
Oh, thank you. It's actually a big part of our strategy over the last 5 years is to, we were so busy identifying the best places and working to protect them that we didn't put a lot of effort into, well, what is this, how do these impact the community? And over the past 3 to 5 years, we put a lot of thought into that. Most of the 20 miles of hiking trails have been established in the last 7 or 8 years. You'll notice new signs, trailheads. We just received a very exciting grant to add some interpretive signs at some of our preserves. We're going to be launching a brand new website at the late winter, which is going to be a lot more interactive as far as finding more about all these special places and how we can better impact the community. Because these places, once we make them available and open to the public. So our goal is to now how these places can impact the community to the best, and we've been putting a lot of thought into that. Well, great, we have lots of food, so take some with you, because otherwise Cinnamon and I have to pack it all up. So feel free to grab a napkin, take something with you, and thanks for coming, really appreciate it.